Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer.
In today's episode of the Labour Justice Barometer, we talk about an invisible form of discrimination, but a form of discrimination which is nonetheless deeply embedded within the workplace and perpetuates inequalities. That is appearance discrimination. In our discussion, we draw on Aisha's recent Mail and Guardian piece, as well as her article in the Industrial Law Journal and her PhD. And we explore how workplace judgments about hair, dress, body type, and professional image, in other words, our appearance, shape access to opportunities, often in ways that go unrecognised in law. While South Africa's equality law framework recognises protected grounds of discrimination, appearance remains largely unprotected unless it can be linked to existing grounds like race, colour, gender, or religion. This creates a legal gap that leaves many workers without clear recourse. So in the podcast, we consider how appearance is not simply about our aesthetics, but it's deeply tied to our identity, dignity, and self-expression, and how seemingly neutral workplace rules can reproduce exclusion. Aisha, so you are our guest today. Thank you for joining us to discuss your recent Mail and Guardian piece. In the article, which was published for Workers' Day on the 1st of May, you describe appearance discrimination as a hidden or quieter form of inequality in the workplace. What do you mean by this? And why do you think it has remained largely invisible in our labour law discourse?
Thanks so much, Debbie. It was great to talk about this area of law. I describe appearance discrimination as a hidden inequality because it doesn't present as obviously as race or gender discrimination, but it quietly shapes our everyday workplace experiences. And, we tend to focus on wages, job security, and unemployment, which are, of course, very critical for South Africa. But we often overlook how workers are judged on how they look. For example, their hair, their dress, their body type, or just their general physical presentation. And what makes it hidden is that it's often normalized. It's framed as professionalism or organizational culture, so it doesn't immediately register as discrimination. But for many workers, especially those from historically marginalized groups, it becomes a real barrier to equal treatment and opportunity. And that is what I argue, that appearance is not just aesthetic. It's deeply tied to identity, to our dignity and our self-expression. The way people present themselves can reflect their culture, their religion, their gender identity, or simply their personal autonomy. But when workplace policies require individuals to alter that, whether it's changing their hairstyle, removing cultural symbols, or conforming to narrow standards, it's not neutral. And it can actually undermine a person's sense of self and belonging. And that's why this becomes a dignity issue and not just a preference issue.
So in South Africa, we obviously have a fairly robust equality law framework and the protection of dignity. Section 9 of the Constitution protects us from unequal treatment or unfair discrimination. And of course, we have the provisions of the Employment Equity Act. But still, you've argued that there's a gap in our law when it comes to appearance. So for you, Aisha, where exactly does the law fall short?
So, Debbie, 100%, South Africa's equality framework is very strong, but it doesn't explicitly recognize appearance or physical appearance as a protected ground. Our Constitution, as you mentioned, Section 9 and Section 6 of the Employment Equity Act protect listed grounds like race, gender, religion, culture, but physical appearance beyond those categories falls through the cracks. So unless appearance discrimination can be linked to one of those protected recognized grounds, there is no clear direct protection. So this inevitably creates a gap in the law. And in practice, this means employees would have to either, rely on unlisted or arbitrary grounds or try to fit their claim within existing categories like their religion or their culture. And I think that's difficult for two reasons. Firstly, the burden of proof, Section 11 of our EAA, it's much higher, and the employee must show that the conduct is discriminatory, but also that it impairs their dignity. Secondly, many forms of appearance discrimination doesn't neatly fit into these existing categories. So workers will face uncertainty, and, it leads to the problem that claims are just simply never brought because of this.
Okay, so using the arbitrary grounds category, we know from our case law this is difficult, and it does impose a greater burden on the employee to identify the reason for the discrimination, and also to argue that it was, that the employer's decisions were not rational or fair. So this brings us to the question of the employer's defense. An employer, of course, will often argue that the appearance standards that they put in place, the decisions they take based on our decision, relate to operational requirements, employer preference, whether for, branding purposes, wearing uniforms, being neatly presented, for safety reasons. Of course, occupational health and safety might determine, you and I have written about wearing high heels in the workplace in that regard, or, customer-facing roles might or discipline in the workplace for the disciplinary professions. So where do we draw the line here between what would be a legitimate workplace policy form of regulation, appearance regulation in the workplace? Where do we draw the line between that and conduct or behavior or policies that would constitute unfair discrimination?
Employers do have legitimate interests such as, like you said, health and safety, branding, client-facing roles. Some retail companies might require a certain uniform, and those are 100% valid. But my argument, and I think our argument, is obviously proportionality. The question is whether the rule is, or the workplace rule is, genuinely necessary, or whether it is masking arbitrary or exclusionary standards. Now, our law already recognizes the inherent requirements of the job, but my argument is that this should be interpreted carefully and not so broadly. Recognizing appearance as a listed ground would bring clarity. It would give employees a direct route to challenge this form of discrimination instead of relying on complex arguments. And it would also guide employers by encouraging them to rethink their workplace policies and ensure that they are more inclusive and justified. And I think importantly, it would prevent legitimate regulation, and it would simply require that regulation to be fair and proportionate. And if it does not affect the merits of an individual doing their job, then appearance should not be a factor in preventing them from expressing their identity.
You're listening to the Labour Justice Barometer, and we'll be right back.
So, Aisha, if we take appearance discrimination seriously, and we accept that the law hasn't quite caught up with the types of prohibitions against appearance discrimination that we would like to see, what is it that employers and workers in workplaces can be doing right now to ensure that there is no forms of appearance-based bias and hidden inequalities that impact on workers based on their appearance?
So even without legal reform, because, getting something legally recognized is a very long, arduous process, there's still a way that workplaces can act. They can review their workplace policies. They can, move away from vague notions of professionalism and ask whether their workplace rules are inclusive. They can also create a space for dialogue and recognize diversity in how employees present themselves. And my research and our article also speaks more to this, but ultimately, it's about shifting from conformity to inclusion. And I think the law is very clear when it comes to aspects of protected grounds of discrimination and how this should be dealt with. But when it comes to these types of hidden inequalities, appearance, this requires a more collaborative and a mutual effort from both the employer and employee to ensure that fair practices are followed despite there being no legal recognition as of yet in our law.
So when you speak about no legal recognition, and I know this from, having supervised your PhD, but maybe it would be useful also just to quickly identify some of the types of regulations that could exist and comparative examples. I know that you looked at, for example, Australia, the French Labour Code, and some of the states in the United States. So some of the steps being taken there, am I right? It's around identifying or defining terms such as physical appearance and then creating prohibitions. Do you think there's any value to considering comparative law?
Yeah, Debbie, 100%. I think, South Africa's history is very different to the Western world. And I did look at examples like Australia, France, some states within the United States. And I think, what it was seen was that there is some form of recognition where physical appearance is recognized, where appearance in relation to your weight is recognized. France has explicitly recognized appearance as well. There's in Victoria and Australia, they also recognize physical appearance. America, they've recognized the Crown Act, which actually protects, employees from discrimination against certain types of hairstyles. And I think this is something South Africa can learn from and, adapt to, because we obviously have to shift and progress our equality law as much as possible. And I think looking at comparators is always a strong way to do that.
So I think if we start steering our conversation towards the Labour Justice Barometer question, and where certainly the provisions of our law sits, and our Labour Relations Act or Employment Equity Act sits in terms of regulating appearance discrimination, where does it sit for you on the barometer, Aisha?
So this would have to sit firmly in the red for me, and not because there's been no progress, but because I just think the law has not yet caught up with the lived realities of, South African workers. And I think the absence of explicit protection means many forms of discrimination remain unaddressed. I mean, as we discussed in our article, we saw high heels as a discussion. And, appearance discrimination rarely operates in isolation because it intersects with our race, our gender, our religion, and culture. So the intersectional discrimination faced by employees can also be dealt with in some way by recognizing physical appearance. So, for example, looking at a Black woman's experience of hair regulation is not just about appearance. It's about her race, it's about her gender combined. Or, for example, if you have a Muslim hijab-wearing Black woman who dresses modestly, this may also impact not only her race and gender, but also her religion and her culture. So these are all overlapping forms of disadvantage which compound the harm, and I don't think our legal framework always captures that complexity. And I think if we have to move the barometer towards the orange and eventually the green, I think it requires both a shift in workplace culture and hopefully eventually legal reform. What are your thoughts on this, Debbie?
Yeah, Aisha, I think you've explained some real complex areas where discrimination arises in ways that we might not think about on a day-to-day basis. It also raises complexities when we think about how do we do this in law reform. And what comes to mind actually for me is the type of protections or approaches to shifting workplace culture that we see. For example, in the ILO's recent Convention 190, which is around preventing violence and harassment in the world of work. But of course, harassment is often linked to forms of discrimination. So the convention itself is anti-discriminatory. And it talks about the need to shift culture, and to move towards cultures of mutual respect and dignity. And I think if we try to practice, mutual respect and dignity for people's expression, then we will make some. My worry is putting hard commands and hard prohibitions in law without shifting the culture. So I agree with you. On the other hand, I do think, and you acknowledge this, we have made progress as a society that strives to be inclusive. But of course, there are often these hidden forms of discrimination. So I think if we're consciously trying to shift our cultures towards inclusivity and transformation, along with that, we have to think about mutual respect for a person's identity, which they may express through their physical appearance. Aisha, that brings us, I think, towards the end of our podcast. But thank you so much for sharing your thoughts on this. And I know you've spent a lot of time writing and exploring also with other authors around these issues. So I'm very pleased that we could have this conversation. And of course, we will leave links to Aisha's article and some of her other work, and also an interview last week. So thanks so much, Aisha, and I'll see you in our next podcast.
Thanks, Debbie. See you in the next one.
This podcast is not intended to constitute legal advice.